Good morning.
Yes, perfect.
The topic for our first program this morning is Federalism Reignited, a view from D.C. The second Trump administration has made a priority of pulling back the reins on the regulatory excesses of the Biden administration. For 8 months, we've seen a raft of executive orders and agency actions in the areas of immigration, civil rights, including the Second Amendment, education, and the environment. Surely more are to come. President Trump and his Education Secretary Linda McMahon have moved in the direction of closing down the U.S. Department of Education. The president has proposed billions of dollars in rescission, with perhaps more to come. What are we to make of these developments? Is this the dawn of a new golden age of fiscal and regulatory restraint? Will the Trump administration's fiscal and regulatory program result in more authority for the states? To help us understand the current political climate in D.C. and how it may shape the relationship between the federal government and the states, I'm pleased to introduce the participants in this morning's Fireside Chat. First, Harmeet Dillon is the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. She was appointed by President Trump and took office in April of this year. Prior to joining the Civil Rights Division, Ms. Dillon founded both the Dillon Law Group and the Center for American Liberty, a nonprofit organization dedicated to pursuing civil liberties claims. Her law practice focused on First Amendment and free speech, civil rights, and campaign and election law issues. Assistant Attorney General Dillon attended Dartmouth College, where she was editor-in-chief of the Dartmouth Review. She then attended the University of Virginia School of Law and served on the editorial board of the Virginia Law Review. She later clerked for the Honorable Paul Niemeyer on the United States Court of Appeals for the Fourth Circuit. Our second panelist is Jesus Osete. Mr. Osete is the Principal Deputy Assistant Attorney General for Civil Rights in the U.S. Department of Justice. Previously, he served as General Counsel to the Missouri Secretary of State, Deputy Solicitor General of Missouri, and Deputy Attorney General for Special Litigation. Before joining the Missouri Attorney General's office, Mr. Osete worked at Bryan Cave Leighton Paisner LLP in the Appellate and Supreme Court Group. He also clerked for Judge Bobby Shepard of the U.S. Court of Appeals for the Eighth Circuit and Chief Justice Zell Fisher of the Supreme Court of Missouri. Mr. Osete is a graduate of the University of Arizona and the Washington University School of Law in St. Louis, where he served as Senior Executive Editor of the Washington University Law Review. Our moderator is Matt Kuhn. Matt Kuhn serves as the second ever Solicitor General of Kentucky. As Solicitor General, he oversees the office's civil and criminal appellate litigation and supervises the office's filing of amicus briefs throughout the country. Since joining the Attorney General's office, Matt has argued on behalf of the Commonwealth in the Supreme Court of the United States Court of Appeals for the Sixth Circuit, and the Supreme Court of Kentucky. Before joining the Attorney General's office, Matt served as Chief Deputy General Counsel to the Governor of Kentucky. He also worked in private practice at Jones Day in Washington, D.C., and Stolkin and Ogden here in Louisville, and was a law clerk to Judge Raymond Grudner of the U.S. Court of Appeals for the Eighth Circuit. He's a graduate of Furman University and the Columbia Law School. Please join me in welcoming our distinguished panel.
Well, thanks, Aaron, for the introductions, and Harmeet, Jesus, thanks for coming all the way to Kentucky. We're thrilled to have you here. At the top, before I ask any questions, I want to take a moment just to thank you for your public service. Both of you guys left comfortable jobs to go to the upside-down world of Washington, D.C. and help implement President Trump's vision at the Civil Rights Division. Please know that here in Kentucky, your public service is really deeply appreciated. Our group here today is really excited about this discussion because what the two of you are doing at the Civil Rights Division has really mattered here in Kentucky and in Louisville in particular. What we're going to talk about today is not abstract for us as Kentuckians. But before we get there, just a couple of introductory questions. Harmeet, I've heard you tell the story about how you got offered the job as Assistant Attorney General of the Civil Rights Division. My memory is you got a very fun cold call from Mar-a-Lago. So can you tell the group here about that call that you got and why you decided to jump back into the fray?
Well, thank you for the warm introduction, and it's a real honor and pleasure to be here. I'm very passionate about civil rights, and this is an honor of a lifetime to be able to serve in this position. So I was one of President Trump's many lawyers on many cases during the campaign. My partner David is the White House counsel, another partner is deputy White House counsel, and the two of them had already decided to go into the government, and it's a small firm, you know. Started from 2 people, and now it's about 40 people, and I had not had a plan to leave the firm that's named after me and go into the government, and I think it was late November, and I got a cold call from the president, Pam Bondi, and Elon Musk, who were sitting around a table at Mar-a-Lago, and they all said hi, and I was like, hi, you know. You know, we think you'd be great for this position, and, you know, I said, well, I'll be honored to serve in any way that you want, Mr. President-elect. And so, yeah, I flew down to Mar-a-Lago and, you know, had a meeting with Pam, and the rest is history. So I don't think I fully grasped the crushing burdens of having to divest yourself of a successful law practice and everything you've done for 20 years and move to the swamp. I have beautiful homes in California. So it was a lot, but it's really turned out well. We've had a tremendous group of people have come to join our mission.
Well, we're glad you went to the swamp. Jesus, you and I got to know each other while we both worked in state AG's offices, in particular while we were pushing back against the COVID-19 mandates. You argued one of the biggest cases against those mandates in the U.S. Supreme Court, and to this day I remain amazed at how willing so many Americans were to give up some of our most precious liberties. And I have to think that what you did on those COVID-19 cases affects how you think about the role that you have now in the Civil Rights Division. Can you talk about how your experience during COVID and being on the front lines of that fight affects what you do today?
Sure. Well, first of all, let me join General Dillon by thanking you for the warm introduction. Full disclosure, I know this man. You are very lucky in the Commonwealth because Matt Kuhn is an incredibly talented litigator, and I got to see his work firsthand. And you've had really good people coming out of that office. Chad Meredith, hopefully soon. Judge Meredith, good friend of mine. Vic Maddox. Just a great team all around. And it wasn't just that we were in the trenches, you know, fighting those battles, but you have some pretty good judges here in Kentucky who may have not won that battle at the circuit court level, but ultimately, and we know who that was, he was vindicated at the Supreme Court. What he doesn't tell you is there was 2 cases that went to SCOTUS. We won the 6-3 OSHA mandate, which was all the private employers. But the one argued, I lost 5-4. That was the CMS lawsuit. But in any event, I thought that the Sixth Circuit judges had the better view of the law, so I was glad they were vindicated. You know, there's just so much that you can learn from the state AG world and apply to the Civil Rights Division, certainly at the DOJ. I frankly think what we do now, and again, I was Deputy Attorney General under Eric Schmidt, who's now U.S. Senator in the Senate, and he was Attorney General at the time, along with General Cameron as well. You know, a lot of the stuff was fighting the government, as your Attorney General said earlier, being on the opposite side of the V, looking over your shoulder as to what the government's going to do today, what, you know, twisted reading of the law to impose some new mandate or some new, you know, regulatory action over the states. What are they going to come up with now? And the Attorney Generals are so pivotal to pushing back against all of that. And so I think the policy development, the in the trenches, you know, armchair litigation that happens at the state level, the kind of experiences you can bring easily translates to what we're doing at the DOJ today. You know, just in the last 48 hours, we're suing all kinds of states over, you know, voting matters. We just filed an amicus brief in the Calais decision on pushing back against an interpretation of Section 2 of the VRA that would allow predominant race-based, you know, districting. Harmeet personally just argued a case in the Seventh Circuit against Governor Pritzker's ban on assault weapons in Illinois. So we're doing everything. But to be clear, the AGs here in Kentucky especially, they're doing the same thing. And it requires a partnership with the feds and with the state AGs to push back against some of these things. And even though we're the ones sort of taking the more national fight, the state AGs are there as well, and you know, you have your own battles to fight here at home as well, and I'm so glad that someone like you is at the forefront of that, because you are a very talented litigator, so I appreciate the invitation.
Well, the sense that I get from Kentucky is that you guys are running the Civil Rights Division a bit differently than it's been run before. And I think what I want to ask you about is, I think it's natural that it would look different than past Democratic administrations. But I think it's also fair to say that what you guys are doing in the Civil Rights Division is different than past Republican administrations as well. The AG called this the great pivot from President Biden to President Trump. Can you talk about what the great pivot looks like in the division y'all lead?
Well, yeah, so my career path has been a little different than the traditional Federalist Society mode. I did a decade in big law in London, New York, whatever. And then I really wanted to do the kind of work that I cared about. So I started my own law firm. And for the last 20 years, I've been doing plaintiff's civil rights litigation on the right, which wasn't a thing that I could have done coming out of law school at UVA in 1993. There wasn't a career that you could do. So I developed that, and I've been passionate about it for all these years. I was in those COVID cases as well. At the Supreme Court, I represented Daily Wire in the challenge to the OSHA mandate. And so what I'm trying to say is the people who usually get this job of Assistant Attorney General for Civil Rights in a Republican administration is typically someone who doesn't do plaintiff's employment discrimination or, you know, conservative litigation to challenge corporations and vaccine mail. They're usually big law partners and so forth. And so they don't have that passion or zeal. And then secondly, those aren't administration priorities, affirmative civil rights. In fact, the way it's been described to me is the best that you could expect in a prior Republican administration is take the 10 out of 10 bad of the worst left-wing part of the United States Department of Justice and dial it back to 8, 9, maybe 7 if you're really successful. Just slow down the bad. And I didn't want to do the job that way. I mean, I made it clear in my interview that if I were to take this job, I would be doing affirmative federal civil rights litigation to advance the administration's priorities. And the Attorney General supported that. And of course, the White House has been sending us these executive orders a lot. And a lot of them have to do with the work that we do in the Civil Rights Division. There's 11 divisions in the Civil Rights Division. But the first thing I did to really change the culture, and again, there were a lot of naysayers. I've even had federal judges who, I won't say who, I've had federal judges call me and say, you know, if you take that job, like, first of all, it's gonna be miserable. You're gonna hate it. And you're never gonna get confirmed again if you do it well, because you're gonna break so much China. And I said, I don't wanna get confirmed again. I actually love being, you know, in my old law firm. I can't wait to go back there. So, but my approach was, let's go in and do this correctly, this job. And so I did my HR training the first week and all that stuff, and how to handle a skiff. And then the second week, I've drafted short memos to all of the sections. And the memo said, these are the statutes we enforce, be it all the voting statutes, discrimination statutes, disability, redlining, you name it, a whole panoply of statutes. And then this is the relevant president's executive orders or policies that we're going to be enforcing as our administration's priorities. And whatever you were doing before, you can forget that, because we're not doing that anymore. And that cost 200 lawyers to quit in the Civil Rights Division. Some who had been there one who had been there for more than 5 decades. And so now, there was also an offer from the government for people to take early retirement or severances, so a lot of people wanted to do that anyway. But some of these folks had borrowed in and stayed through multiple Republican administrations, not changing what they did one bit. So then there's a high level of resentment. And then on top of that, we started doing the work. We started dismissing things that should never have been filed, withdrawing them, taking the opposite side on multiple cases. I mean, the fact that we, for the first time, stood up in court on Monday and said that the United States believes that Illinois' so-called assault weapons ban is unconstitutional, is literally would have blown the minds of those 200 people and then some. So we're down even further than that. But something else wonderful happened, which is I'm somewhat more senior than people who typically take this job. I have a lot of relationships. So I was able to recruit some great lawyers from all over the country. Jesus is one. But we've had some really fine lawyers leave private practice or their government jobs and come to DC and be in the swamp. One of my colleagues from the Republican National Committee quit his partnership and came up from Florida. So we are the United States' plaintiff's law firm now, and it's never been used that way by a Republican administration.
So I want to ask about that. You're the plaintiff's law firm for the American people is the way to think about the Civil Rights Division.
That's right.
So let me ask how the difference from prior administration. So the idea of the Reagan administration, right, was we want to get the government out and let the free market work. And I think that what you're saying is in some tension maybe with that. And the idea that by not having an active civil rights division that's doing what you guys are doing, things like DEI were able to proliferate because civil rights like that weren't being affirmatively enforced. Is there tension there, and how do you reconcile that?
That's a really great question. So the first point is when I got confirmed, I swore to apply and uphold all the statutes that are assigned to me by Congress, and I actually happen to believe in most, if not all of them. And so I think it is the job of the legislature to get rid of laws that are not productive or that impose a regulatory burden. So for example, you know, if some of these statutes that I am enforcing are no good, Congress should fix that. I've, in my prior life, testified numerous times in Congress regarding voting rights issues and how I think there should be some improvements to some of the statutes that are out there, some clarifications. I've been passionate about Communications Decency Act, Section 230. I've testified about that many times. So I don't think that's our role, but I don't think it's imposing more government for the government to do its job as assigned by the legislature and the executive branch. The president wants us to use the Civil Rights Division to dismantle DEI. And that is a massive sea change. I mean, I can't tell you because I'm doing it, but I'm negotiating with all of these university presidents and their general counsels. And by the way, if you've been hired as a Republican lawyer to represent one of these schools, you're welcome. It's like a full employment act for all my friends. But it wouldn't happen without threats, without me sending letters saying, I understand you're still violating students for fair admissions, please produce this data. Or what's going on with you punishing Jewish students more than other students? Or how come this kind of student can't get to class? What's going on? Anyone in private practice knows that you can't just sort of send polite letters if you never back them up with litigation threats. So I'm a litigator. And we didn't get our appropriate response, filed lawsuits. I've sued California over letting boys take girls' trophies. We sued North Carolina over having 190,000 voters on the rolls in violation of their own state laws in HAVA, and they came to the table at an agreement with us to fix that. And there are numerous other examples like that. Challenging New Jersey's assault weapons ban. I'll be going to the Third Circuit to argue that personally because I'm a gun owner and I'm passionate about that right. And so if Congress eliminated all these federal civil rights statutes and we had nothing to do, I would pack up my shop and go home. But I think that's not for us to decide to just simply go in the job and then slow it down. That doesn't seem to be consistent with my philosophy. One more example for you. The FACE Act is known by conservatives as a law that has been weaponized against pro-life believers and protesters. And I represented many of those, David DeLinen and others, in my private practice. But it also covers blockage and discrimination, violence and vandalism against houses of worship. It's not used for that. We're using it for that. So you can use statutes in productive ways, socially productive ways that are consistent with the administration's agenda, and we're doing exactly that.
Can no discussion about civil rights, I think, is complete right now without reflecting a bit on what happened 2 weeks and a day ago to Charlie Kirk. He was assassinated because of what he thought and what he said. That's front of mind for me in any discussion about civil rights. What role do you think your division has in cases like that? Just open-ended question.
It is an active investigation. We are involved in it. In fact, we have lawyers. Some of my colleagues flew out to Utah earlier this week, right, Jesus? And so we're actively involved in the FBI and local investigation, DOJ investigation. The way, theoretically, a case like that, which, and I'll give two other examples, two Israeli embassy staff were murdered in cold blood in the District of Columbia, and I'm the lead hate crime prosecutor of the United States. And because that crime was motivated by discrimination against somebody because of their religion, that's a hate crime. It provides additional enhancements potentially. You know, Janine Pirro is sort of running point on it, but I have to sign every hate crime prosecution in the United States. And whether you believe in hate crime or not, I certainly sat through a lot of law school classes that debated the concept of hate crime and hate speech, something also that's been in the news. It's on the books, and we're going to use it. And so we have been using it. If we are able to prove that other crimes, like the firebombing of the elderly Holocaust survivors in Colorado, who were simply trying to remember the hostages from October 7th, 2023, hate crime. And to the extent that anybody in this country is murdered because of their religion or their race or the other protected characteristics we're familiar with under federal law, hate crime. The gap is perhaps political viewpoint in the law. Now, I come from a liberal state, California, which had a very good law that I loved and used a lot, which was that you cannot discriminate against people in employment and public accommodation because of their political viewpoint. And I used that as a conservative. It wasn't the way they thought it was going to get used, but I used it. And similarly, I think that's something that Congress should consider, the extent to which, with the volume of political violence in our country that we are seeing today, whether that should be a protected characteristic. There are all kinds of challenges that this concept abuts directly against the First Amendment. Courts are able to, I think, sort that out, and it has been something that I've been thinking about a lot lately. Charlie was a good friend of mine. He came to our offices just a few weeks before he was killed and was always texting with me. I've spoken at probably over a dozen events with him.
Well, can we shift and talk a little bit about the good work that your division is doing, not just here in Kentucky, but here in Louisville, which I think is why this discussion is so important. So we've set the stage for the pivot at the Civil Rights Division, and there are two cases here in Kentucky that Harmeet and Jesus have been involved in. And both of them are ongoing, so I'm going to ask general questions and not ask specifically about the cases. But I do want to set the stage that the first involves a consent decree involving, or proposed consent decree involving the Louisville Police Department here. The Biden administration sued the city of Louisville right before President Biden left office. At the same time, filed a joint motion for a consent decree. The consent decree that would have applied to LMPD was a tome. It was 242 pages long. The consent decree was going to last for 5 years. The court-appointed monitor was going to cost over $7 million. When your predecessors in the Civil Rights Division, the Biden administration, came to Kentucky to defend that consent decree, they faced a very skeptical Kentucky federal judge. And I want to talk about what he wrote and then just ask you about consent decrees generally. So our judge here in Kentucky wrote that this proposed consent decree, quote, displaces responsibilities of elected city officials and the political process in favor of the rulings of an unelected judge. Mm-hmm. So in May of this year, you guys filed a motion to dismiss your case against the city of Louisville and abandon the proposed consent decree. Again, that motion has not yet been ruled on. So I just wanted to ask you, what role, if any, does consent decrees play, and how do you think about the decision that you made for here in Louisville to abandon the consent decree?
Yeah, so a lot of the radicalization, I think, at the Civil Rights Division of the Department of Justice has been in this particular area. And it is exactly as the judge commented, which is that a bunch of young, middle-aged lawyers toiling in obscurity in a faceless government building have been able to supplant the will of the people in dozens and dozens of instances with generally very negative impacts on the jurisdictions affected. And so I learned a lot about these consent decrees in the run-up to deciding which ones we were going to be outright dismissing, which ones we were going to be withdrawing the factual findings of, and that's an ongoing process. And let me step back a little further in time, and there are also good and important and historical consent decrees. I grew up in the Deep South in the 1970s, and Smithfield, North Carolina had Klan signs when I moved to North Carolina. The schools were barely desegregated, and they wouldn't have been desegregated at all without federal judges insisting that these schools be forced to follow federal law as directed by the Supreme Court. And so, but the interesting fact is some of those consent decrees from the 60s and 70s are still on the books. So we have been literally, pre-PACER, finding these cases and trying to figure out, is everyone dead who signed this thing and how are we going to get rid of it? Some real, filing challenges. So we've been doing that also in the...
So you're saying our consent decree here in Louisville wouldn't have just lasted 5 years?
Yeah, I mean, people filed them and forgot. I mean, we had some from Louisiana. Attorneys General came to us and said, hey, we understand let's make a deal time on consent decrees. And, some of them needed to stay in place for different reasons, not the school ones. We're getting rid of a lot of those. But what I learned studying the science of consent decrees is that when a city or a municipality is under a consent decree, the following things happen. First of all, there's a bunch of these lawyers who are micromanaging what happens in these things. Things like, how many of the bites by the dogs are against people of color versus otherwise? And then you have to document that, and then you have to answer for that. And there's no analysis of whether the differential might come from the crime being higher in certain areas because of, whatever conditions in that neighborhood versus otherwise, no, it's just a flat statistical analysis. And we all know statistics can be manipulated. So I was shocked. I came in the office. I'm like, okay, how many lawyers do I have? I'm like, well, you have a bunch of lawyers, but you also have dozens of statisticians. I'm like, I don't need statisticians on my staff. Why do I need that? Oh, ma'am, it's for the consent decrees. I was like, okay. I don't think we need those guys so much. In private practice, you wouldn't have one on staff. You'd go hire an expert if you needed it. And you wouldn't be making your entire case on statistics. And COVID was a multiplying factor of this as well. Most of the lawyers in the DOJ and the Civil Rights Division were working remotely during the entirety of the Biden administration. And again, I'm a little country trial lawyer, but didn't really work. Didn't really work when people are not there in the office and accountable, particularly young lawyers. They're not learning how to be lawyers, and we see this in the quality of these consent decrees. Just to be brutally honest, 2 consent decrees that were filed in Minneapolis and Louisville, deeply flawed legal theories, deeply flawed methodology, cherry-picking incomplete data, and then punishing and burdensome remedies that had nothing to do with George Floyd or Breonna Taylor getting shot. Insertion of officer wellness programs, unaccountable community boards that were able to micromanage police departments. None of that is in the Constitution. None of that is in a statute. It's just the DOJ has overwhelming power and can force cities to do whatever is necessary. And there's a complicating factor is in the last 20 years or so, you would have seen all the cities fight against these in the olden days, and they did. They don't fight against them anymore because the people in the city councils of our major American cities are welcoming these with open arms. They welcome federal oversight and micromanagement that they can't obtain. They welcome maybe, some grants or whatever that comes along with it, but they welcome punishing their own police departments. So my philosophy is very simple. 2 cops do something bad, we should absolutely, first of all, check with the locals. Are you guys going to prosecute that bad cop? What's the likely outcome? That's usually the end of the inquiry for me. I don't need to pile on, I got other stuff to do. If they're not going to do anything, or if it's a jurisdiction like California, or even if the prosecution is 100% aggressive, the person is going to get out in 6 months for shooting somebody in the back, well, we may take a look at that, and we have done that. We're going to go after the bad cops and the bad practices individually. But when you go on to the next step of imposing a federal consent decree, you're talking about an average length of over a decade of a police consent decree. You're talking about an average monitor expense of over $1 million, sometimes in big cities, $20 million a year. I want to say Albuquerque ended up costing over $100 million. And then third, the crime rate goes up in every city. The Ferguson effect happens in every city where you have a police consent decree. The quality of life goes down. The cops move across the river to the place where they can still live in the same house, but they don't have this silly consent decree to deal with. And it's just a bad thing overall. So we have, if I see a fact pattern which requires a consent decree, we'll really think long and hard, but we are not in the consent decree business. And it's even more annoying that literally the prior administration sat on they took years to develop these flawed cases, and then they filed them after the election.
And then
I think that's so dishonest.
They got to court here in Kentucky, and the judge said, well, I need to see evidence of a pattern and practice of unlawful conduct. And no evidence came forward.
There was no evidence, and secondly, I'm sure both of these judges realized the current administration is going to have a different view of this type of approach. And in addition to the two that we dismissed outright, which is still pending, because people are trying to intervene, liberal groups are trying to intervene and keep them alive, we withdrew our factual findings in a number of other cities. And so I'm proud of that work, and we continue to look for ways that we can reduce the regulatory burdens on our great police. Let's just get rid of the ones who are no good, and let's let the rest of them thrive.
So you've already mentioned the other Kentucky case I wanted to just ask you briefly about, and that is another carryover case from the Biden administration. One of the officers who was involved in executing the search warrant that led to the tragic death of Breonna Taylor here in Louisville in 2020. That officer was first charged by the previous AG with wanton endangerment. Full trial there, he was acquitted. And then the Biden administration followed up and brought civil rights charges and went to trial again, got a hung jury, so he's gone through 2 trials. Biden administration, before the election, did a 3rd trial, and they got a split verdict in the case, one count guilty, 1 count not guilty. And then President Trump took office, and so you guys had to figure out how to navigate the sentencing of that, and you guys filed a sentencing memorandum, and I just wanted to read a short passage from it and then just ask you how you guys approach cases like this. So what you said in your sentencing memorandum is that you're, quote, unaware of another prosecution in which a police officer has been charged with depriving the rights of another person under the 4th Amendment for returning fire and not injuring anyone. So with that background, and this is a case that there's been a lot of focus on here in Kentucky. How do you guys approach a case like that brought by the Biden administration? How do you approach it differently?
Well, first of all, and there's a lot of debate in our building what we do, because on the one hand, we are law enforcement officials, and on the second hand, we are lawyers. And when a jury returns a verdict and the judge doesn't reverse it, you're stuck with it. You have to respect it. We're law enforcement. We can be like, oh, let's ignore these juries. So you have to somehow harmonize that with the policy. But you look at the facts of this case, indeed, the bullet that killed Breonna Taylor did not come from Officer Hankison's weapon. The theory of the Department of Justice Civil Rights Division criminal section was that by returning fire blindly and recklessly, he effectively detained her and pinned her in place so that she could not leave. And that is what created the conditions for someone else to shoot her in the middle of the night. I mean, I would never have brought this case. I would never have approved this case. And yet, the government did, and there's a jury verdict. So we have to respect that, but also have to, I like to say in speeches, and I like Jesus, like my entire career has been suing the government. Like, this is very novel to be the government, for me. And it's frustrating the way that the DOJ has such overwhelming power sometimes, and it just seems like they're just getting whoever they can. It's the Department of Justice, not the Department of Convictions. And so while there's a conviction here, we felt like the outcome should do justice. So we had a sentencing recommendation that was quite controversial. The officer had spent a day in custody, and we recommended that as the sentence. That's not what the judge accepted, but it was a lot better than what the guidelines range indicated.
Yeah. You guys have both.
Jesus may add to this.
The other thing, you're noticing a pattern, right? In the sense that, when we come across a shortfall or something with respect to statute, Her response is, amend the law, reflect whatever the policy, whatever value judgment you want to, let the law reflect that, so to speak. As you recall, for the last 4 years, certainly before the president was inaugurated, that wasn't the response. The response was, I get to forgive student loans. I get to make you take the shot. I get to do all these different things in these long, extant, dormant statutes with these funky theories. And, it's no different in Hankinson. I mean, that theory, frankly, I've read the case law pretty extensively. There's some judges on the Sixth Circuit that think that theory is probably not going to live to see another day, potentially. But we'll see. I mean, there's a pending appeal on that. But that's the pattern, is we at least have limitations. We at least say we're operating within the bounds of a reasonable interpretation of the four corners of a statute. The other folks were not doing that, and that's what we're reviewing day after day after day, is that these police officers who their liberties have been deprived for so many years, this cloud has been hanging over them for so many years, why is it that if the Department of Justice and the city of Louisville agree that, and it's an unopposed motion to dismiss this consent decree, that some group in New York can say, no, we know better what's better for Louisville. You elect the people of Louisville, not some group out of New York. But that's what we're seeing. And so we at least have limitations. We're operating in good faith. We're actually doing things within the bounds and having a debate about what the law is, which is why, I always say, why are the conservatives always shooting at each other? Well, because we're actually debating things, okay? The other side's not doing that. And that's the thing that we've been pushing every day, is let's debate these things. We don't always agree on stuff, but let's not just say, okay, we're gonna adopt some interpretation that has never been adopted before, and it's gonna result in a policy outcome that is not gonna be good for us in 4 years.
So, the notion that the city of Louisville is better situated to oversee its police system, I mean, that's just federalism. Like the states get to decide these issues, and I think that DOJ recognizing that limit after they have run roughshod over states' rights for years and years is just, that's the paradigm shift of your division. And you stole a little bit of my thunder about the Second Amendment, but I think it's unbelievable that you went to Chicago and crossed swords with Judge Easterbrook this week, and that you're getting ready to go to the Third Circuit, I hear, to do the same thing. One of the things that, as a state SG, that confounds me about the Second Amendment is that you can possess an AR-15 just depending on which state, which judicial circuit
Right.
you're in, and apparently not in the Seventh Circuit, not in the Second Circuit.
Not in DC,
Not
where
in
I would
DC.
like to have an AR-15 myself.
So it's obviously a big deal that your division is getting involved in that. I think the Supreme Court's got to, at some point, talk about how Bruin applies. Can you just tell us kind of how you think this is going to play out, and what
Yeah.
role you guys have in getting us to there?
So there's a percolating circuit split that's happening on this very issue of the extent to which state assault rifles, I mean, they're not really, that's like the whole argument is AR-15s are used for a broad category of sporting and defensive purposes, whether they're constitutional. And Justice Thomas has left some breadcrumbs in dissents from denial of cert on these cases, including this particular case, where there was an injunction issued by the district court, and then the Seventh Circuit fashioned a random, I think, militaristic test, which is at odds with longstanding development of recent jurisprudence on the Second Amendment, and I think at odds with Bruin and Heller. And the Justice Kavanaugh, writing a statement about denying cert at the time of that case, said the reason we're denying it is because there is a circuit split. Let's get all of the circuits to take a position, and then let's decide it. But Justice Thomas has come out and said AR-15s are clearly arms in the first part of that test, and they're clearly not unusual. They're common, and they're not unusually dangerous or anything. They're the most popular civilian rifle in the United States is the AR-15, and yet I can't have one in DC, and I can't have one in California. So, these are some of the things that I think are very important. I do expect the Supreme Court to take up whatever happens I don't know if you heard of it, a pretty forceful argument with Judge Easterbrook about this. He's really wedded to his militaristic standard, and parties can't say it so much, but an amicus can come up and say, well, Judge, that's totally wrong, and
Respectfully.
There
Sir?
was no respectfully there. You're wrong.
well, he interrupted me in my first 1.5 sentences in, he interrupted me, and I was like, if I may finish, that standard doesn't exist in the law. And so it was kind of fun to be able to have the United States take a position on that. And I feel good about the trend in the jurisprudence, but it is past time for us to clean that up. And, some of the concerns of, like I said, I'm mainly a trial lawyer, not an appellate lawyer, but, the standard is circular, et cetera, et cetera. And his follow-up question to me was, well, what if different courts reach different results? I'm like, well, you're a court of appeals, so that's kind of what you do, figure that out, So it's going to be fun to see how the Supreme Court does that.
Well, I think we've got about 5 minutes for 1 or 2 questions from the audience. So let's do that, and please make your questions in with a question mark and be short. So right there.
This is an issue that I've been wrestling with for a couple months now. So I grew up in the West End, and you spoke about how your office kind of checks back cops. What about absent cops? And the question that I was working with is whether it violates the Equal Protection Clause under Village Rule of Law if the police officers are not going to different areas the same way they're supposed to. Growing up, police officers would come to the West End after dark. I'd be interested to see those response times. Is there room to end the Equal Protection Clause argument there? That's just something I'm thinking about.
It's an interesting question, and so I'll speak in general terms. I mean, I've sued the police in San Jose for standing there and watching while Trump supporters got violently assaulted, and confronted that very question as to what is the duty of the officers to do their jobs. But I think there theoretically could be a pattern and practice issue. If there's simply a policy of abandoning certain areas of the jurisdiction based on a protected category, race, et cetera, that could be a violation of equal protection. So I would have to look at these specific facts, and is there a pattern in practice? What is the practice? How do you define it? And what is the effect of that? Jesus?
So you have a pending case right now, or it's something?
Not a pending-
Okay.
So I grew up in the West End.
Yeah.
And my grandmother still lives there. And this is no stats, just knowing how police officers are. Don't arrive after dark. The drug dealers are the ones who tend to pay for this.
Right.
It's not a bad police officer problem. It's an absentee police officer problem, where on other sides of the city, they're patrolling at night and keeping those areas safe, but they ignore the West End.
If I can add one more point, one of the factors in the Louisville consent decree issue was the fact that the city of Louisville had agreed to have its own monitor at the state level. And so I think really the problem here is a political one. I mean, the people of the city should demand that they get what they pay for as taxpayers, all the people. And so federal government taking its heavy hand out of the equation doesn't really solve the problem for Louisville, because they weren't pushing back on the federal consent decree. They were ready to do it, and they were happy to do a state one as well. So I think that's a political accountability issue at the highest level.
One more question? All right. Well, if not, please join me in thanking Harmeet and Jesus for coming.